Jasmine Crockett did not come to that hearing room to perform. She came to prosecute. And there is a difference, a significant one, that becomes visible the moment she starts speaking. Because performance is about the audience. Prosecution is about the target. And from the second she took the microphone, every word she directed at Pam Bondi was aimed at one thing. Not applause, not a viral clip. The truth about $2.3 million that moved out of the United States Department of Justice and into 3 offshore accounts connected to Jeffrey Epstein's name. Bondi had survived the morning session. Standard answers about prosecutorial independence. She looked composed. She had no idea what Crockett was holding. The folder was manila, unremarkable. Crockett set it on the desk without ceremony. No theatrics, just the quiet confidence of someone who has already read every page inside it. Madam Attorney General, I want to ask you about a payment, a specific payment. $2.3 million, transferred out of accounts connected to the Department of Justice between February 8th and February 24th of this year. Routed through a shell company in the Cayman Islands, dispersed to 3 separate offshore accounts, one in Switzerland, one in Singapore, one in the British Virgin Islands. And at the bottom of the final transfer authorization, a notation that I want you to explain to this committee. Payment in full for settlement of claims related to J matter. Crockett looked directly at Bondi. What is J matter, Madam Attorney General? The question was simple. 4 words. What is J matter? Everyone in that room knew the answer. J matter was the internal DOJ designation for matters connected to Jeffrey Epstein. It had appeared in prior document releases. It was not obscure. It was a paper trail with a name on it. Bondi's response was immediate and practiced. Congresswoman, Crockett corrected without raising her voice. The correction was quiet but surgical. It landed in the room the way a blade lands. Clean, precise, leaving a mark. Bondi reset. Congresswoman, I am not in a position to discuss the specifics of confidential legal settlements in an open hearing. Crockett nodded slowly, the way someone nods when they were expecting exactly that answer and have already prepared for it. I understand that, so let me ask you something you can answer. Were you aware, when you were confirmed as Attorney General of the United States, that your department had an active financial obligation connected to Jeffrey Epstein? Bondi paused. Not long, but long enough. I became aware of certain ongoing legal matters in the course of my transition briefings. Crockett leaned forward. Certain ongoing legal matters. $2.3 million routed to offshore accounts in 3 countries. You would describe that as certain ongoing legal matters? Bondi's jaw tightened. Congresswoman, I cannot characterize the nature of sealed settlement agreements in this setting. Crockett picked up the first document. You may not be able to characterize it, but I can, because I have the bank records. What followed was methodical, document by document, precision over passion. The first deposit, $847,000 from the Department of Justice Financial Management Division on February 8th. 2 days after Bondi was confirmed. Destination, Executive Branch Consulting Services, Cayman Islands. No employees, no physical address, no operational history. Authorized by Bondi's Deputy Assistant Attorney General with the notation, Legal Settlement, Executive Privilege Claim, Classified Matter. The second deposit, $293,000 from an entity called the National Security Litigation Fund, arriving in the same account 4 days later. Crockett paused on that name. The National Security Litigation Fund. She said it twice, slowly, because the name itself was designed to sound legitimate, to sound like something that belongs in a government building. And maybe it did, but no one at that hearing could explain what it was, who funded it, or why it was sending hundreds of thousands of dollars to a shell company in the Cayman Islands connected to a Jeffrey Epstein settlement. The third deposit, $1.2 million from something called the Presidential Legal Defense Trust, Its presence in this transaction, flowing into the same account, the same shell company, as part of the same $2.3 million that bore Jeffrey Epstein's name, was not something Bondi could explain with a reference to classified legal proceedings. And then Crockett read the notation. Payment in full for settlement of claims related to J matter. She set the document down. She looked at Bondi, and then asked, Madam Attorney General, who authorized this payment on behalf of the United States Department of Justice? Bondi's lead attorney moved to intervene. Bondi stopped him. She was going to handle this herself. Congresswoman, I cannot discuss the particulars of sealed settlements. The authorization process follows established protocols and, Crockett cut through it. I am not asking about the process. I am asking about the person. Who signed off on $2.3 million going to a shell company connected to Jeffrey Epstein? Give me a name. The silence that followed was not brief. It was not the half-second pause of someone gathering their thoughts. It was the kind of silence that fills a room, that makes reporters stop typing, that makes committee members look up from their phones, that makes the C-SPAN camera operator zoom in because something is happening that does not happen often in these rooms. 83 seconds. Crockett timed it. For the Attorney General of the United States to respond to a question about who authorized a $2.3 million payment connected to Jeffrey Epstein. When Bondi finally spoke, it was not an answer. It was a referral. The authorization process involves multiple levels of departmental review, and I would need to provide that information to the committee in writing. Crockett looked at her. In writing. You sat here for 83 seconds, and what you have for me is in writing. She picked up another document. Let me help you with your memory, Madam Attorney General. This is a Department of Justice internal memo dated February 11th, 3 days after the initial wire transfer. Subject: Executive Branch Protection Protocols. It designates all documents related to Settlement Agreement EP0225 as attorney-client privileged and exempt from FOIA requests. It was distributed to all division heads. And it bears the reference signature of your office, not your deputy, your office. Bondi said nothing. Crockett continued. 3 days after $847,000 left your department and landed in a shell company with no address and no employees, your office issued a memo classifying everything related to that transaction. Why? Bondi's response was careful. Classification decisions are made to protect ongoing legal interests in sensitive... Crockett raised her hand. She didn't slam it on the desk. She didn't raise her voice. She just raised her hand, the way a teacher raises a hand to pause a student who is heading in the wrong direction. The gesture was more devastating than any outburst would have been, because it was dismissive without being aggressive. It communicated something precise. I have heard this answer before, and it is not going to work here. I want to talk about the Treasury Department, Crockett said. Because 6 days after that wire transfer, a Treasury analyst flagged the transaction. Unusual activity. Potential SAR filing required by law. The receiving entity, Executive Branch Consulting Services, had no employees, no physical address, no operational history. The analyst believed federal banking law required a suspicious activity report. Their supervisor's response was 3 words: do not file. The matter was classified. Executive branch decision. She set that document down too. An executive branch decision overruled a legal requirement to report suspicious financial activity connected to a Jeffrey Epstein settlement. Madam Attorney General, who made that executive branch decision? Another silence. Shorter, but heavier. Bondi now understood the architecture, each document connected to the next. Each question closed an escape route the previous had already blocked. Crockett was not finished. She reached into the manila folder one more time. This is a list, she said. A Department of Justice internal document, created in 2023 and updated in 2025, during your tenure. It is titled Individuals Excluded from Epstein-Related Investigative Activities. 47 names, each assigned a protection code. She read them. Code A, Political Sensitivity. Code B, Diplomatic Relations. Code C, National Security. Code D, Executive Branch Protection. She looked at Bondi. 12 names on this list are protected by direct order of the executive branch from Department of Justice investigation, updated while you were Attorney General. She paused. Did you authorize these exclusions? Bondi said she could not discuss the contents of classified internal documents in an open hearing. Crockett nodded. I understand. So let me make sure the committee understands what we have here. We have $2.3 million that left accounts connected to your department and moved to offshore accounts in Switzerland, Singapore, and the British Virgin Islands. We have a classification memo issued from your office 3 days later. We have a Treasury analyst overruled by an executive branch decision. We have 47 names excluded from Epstein-related investigation, 12 of them by executive branch order, in a document updated during your tenure. And we have 83 seconds of silence when I asked you who authorized the payment. She gathered her documents. I want the committee to sit with that for a moment. Not because I am accusing the Attorney General of a crime, but because the American public has been waiting for years for someone in this room to explain how $2.3 million connected to Jeffrey Epstein's name moved through the United States Department of Justice and ended up in offshore accounts that nobody can fully account for. And what we got today was 83 seconds of silence and a promise to respond in writing. Bondi's lawyers were already in damage control. But damage limitation is a losing strategy once the documents are in the record. The record does not limit damage, it simply records. What Crockett did in that room was not dramatic in the conventional sense. No shouting, no theatrical outrage, something more durable. A methodical, document-supported dismantling of the claim that the Epstein case is closed, that the money has been accounted for, that the silence of the powerful is the same as the innocence of the powerful. 83 seconds told a different story. Not because silence is guilt, but because in a hearing room, under oath, in response to a direct question about who authorized a payment connected to Jeffrey Epstein, silence is the loudest possible answer. It means the truth is still considered more costly to speak than the political price of saying nothing for 83 seconds in front of a congressional committee. The documents are in the record. The silence is in the record. The $2.3 million is in the record. J Matter is in the record. And Pam Bondi's 83 seconds are in the record, right next to her answer when she finally spoke. I would need to provide that information to the committee in writing. The committee is still waiting.